I have a few warnings before we get started. This is not a substitute for legal, tax, or investment advice. You need to speak with your own advisors as to what's best in your particular situation. We have clients complete a 2-page will intake form when for our first meeting with for their estate planning. We have a tremendous amount of material to cover in a short period of time, so I'm going to ask you, even with a small group like this, to hold your questions to the end. I'll answer your questions during the question and answer session, and I'll stay after, or if you want a free consultation, just call me. If you want a free Medicaid or estate planning consultation, just call me. We have the intake forms here that I can give you, or we can email you a link to that. I always say be careful what you wish for as far as avoiding probate and planning for Medicaid. I'm in my newsletter, I also have a list of the seminars I'm presenting on 14 ways to preserve your assets with the Medicaid laws, which we'll allude to a little bit in this presentation. How many people here have wills? Okay. How many people here have powers of attorney? Okay. What about healthcare proxies? Has anyone done a living trust? What about a life estate deed? Okay. So, like I said, everyone's particular situation is different, so you need to speak with your advisors, see what's best in your particular situation. We all have different issues. We deal daily with brothers and sisters that are fighting, sibling rivalry. Often many people unfortunately may not have seen their kids for 10 or 20 years, so they may want to exclude them from their wills. It's a sad commentary, but it does happen quite often. This sibling rivalry can be very expensive when you have brothers and sisters fighting in probate proceedings. That's why you need to plan things out, get the proper executor. As far as asset protection, some people, I can say we have these different factors, and we will give you enough information so you know what questions to ask when you do talk to your individual advisors. Some people are concerned about protecting their assets if they go into a nursing home. That's usually a key factor. Most of our clients, their primary asset is their home, and they want to preserve it for their children. However, I do caution people, if their home is their only asset and they give their house away to save it in case they have to go to a nursing home, they will have a very difficult time getting into a nursing home or even getting rehab services. So what happens, someone never plans on going to a nursing home, and people say, I'll never put my mother or father in a nursing home, but they break their hip, then they need to find a rehab facility very quickly, and the rehab facilities don't want to get stuck with them as long-term care patients, because does anyone know how much it costs every day to go be in a nursing home? It's $500 a day, so it's about $15,000 a month. So the Medicaid rate is only about half that. So of course, nursing homes prefer to have private paying patients or residents rather than those that are on Medicaid. So they may say there's no beds available, and they may ship you out down to Gowanda. They can ship you out 50 miles or so. So that's something to keep in mind. And talk to your advisors about that. The consequences of giving your assets away may result in you having a tough time getting into a good nursing home. And as I say many times, even the 5-star nursing homes are not that great. There's very few good nursing homes. Some people are concerned. Like I say, we have all these factors that people have to consider. Some people want to minimize their taxes. There's issues with your property taxes. There's estate taxes. Most people don't have to worry about estate taxes any longer. The federal estate tax exemption is now $12.9 million, and the New York State estate tax exemption is $6.4 million. So when I first started practicing law 44 years ago, it was central as far as planning, but now it's not a big consideration as far as setting your estate up so you don't have to pay estate taxes. New York eliminated their gift tax, but there is a federal gift tax. And that's all wrapped in with the estate and gift tax exemption in federal is 12.9 million. So many of you have probably heard you can give away like 17,000 a year, or used to be 10,000. That's in addition to giving away 12.9 million during your lifetime and in your will and your living trust, you can give away 17,000 to as many people as you want every year. So most people don't need that exemption, but just something to keep in mind if you hear those figures about giving away 17,000. But there again, in my Medicaid seminar, I do caution you, you will still be penalized for, even though it's exempt from federal tax, you'll still be penalized for making gifts if you need nursing home care, which we go into a great deal of detail about how that all comes about in our Medicaid seminar. Income taxes are a consideration. Usually in your IRAs, we'll talk about IRAs in a minute, and 401ks, you should have beneficiaries on there. They can roll over they don't have to cash in your IRA if you pass away. They can roll it over into their own IRA and delay their income tax. So some people are concerned on their estates about privacy. If your estate goes through probate, we'll talk about when your estate goes through probate. That's all public records. You can go on websurrogate.com and look up any estate in any county in New York State and get the information about people's estates. It always has been public information. You can go. You've always been able to go in person and look up estates, or look on their computers down at 92 Franklin Street if you don't have access to the internet. That's all public information. So some people are concerned about privacy. If your estate doesn't pass through probate, we'll talk about that in a moment, that's completely private. Your assets that do not pass through your will, there's about 15 of those, we'll talk about that in a moment, that's all private. So some people are concerned about privacy. Second marriages are a big consideration. If a divorced man marries a woman and the divorced man has 5 kids and his new wife has no kids, he may be concerned about providing for his kids. So usually, a husband and wife, they go to the lawyer's office and they leave in their wills their estates to each other, and otherwise they'll go to the children. Well, if the husband dies with the kids, dies before the wife, she can go and change her will and leave nothing to the kids. So that's a consideration with second marriages, about setting up trusts for that purpose. There's green folders on the tables there if anyone needs a green folder, and there's green folders up here. Some people are concerned about legal fees. We'll talk about probate, but the cost of probate can be considerably higher than setting up your estate, so your estate does not go through this probate process. Financial security for your family is a consideration. How much income and cash flow you're going to need during your retirement, and maintaining control. Some people want to maintain control. Now, if you want to preserve your assets, so if you go into a nursing home, you have to give up control. Either you have to give assets away or put them into an irrevocable trust, which we'll talk about. So that's all what your personal preferences are with your estate planning. And I will say that if you don't plan your estate, we'll talk about it. New York State has a plan for you, but you may not like their plan. There's also considerations about business succession. If you're a sole proprietor, just doing business as all you have is a DBA certificate downtown, when you pass away, your business dies with you. So you have to talk to your advisors about that. If you're in a limited liability company or corporation, those entities go on forever. Those can go on forever. It's just a paper transaction to transfer the stock or the ownership to the next generation. So make plans for that by incorporating or setting up a limited liability company. We could talk about for an hour probably about limited liability companies and corporations. It can be done very quickly and easily, and it may not have any tax impact on you. So also you need to provide, even if you have a corporation or a limited liability company, about someone taking over and having access to the company bank accounts. And some people, usually it's just the president have access to the bank accounts. Have you made provisions for other people to have access to the company business accounts if you pass away? Who's going to make medical decisions for you if you become incapacitated? How is anyone going to know what your wishes are? Do you want to be kept? Do you want tube feeding? Do you want to be kept alive on machines? We'll talk about that also, about how you can plan for someone to make medical decisions for you with healthcare proxies, living wills, and medical orders for life-sustaining treatment. We'll talk about that. What if you become incapacitated? Who's going to manage your finances for you? Do you have a power of attorney for that, or have you set up a trust for that? Who's going to take over and be able to pay your bills for you? Make sure your bills are paid and they don't foreclose on your house. And then, are you interested in providing for your family? And what family members? Like I said, many people are estranged from their children. Some people like their pets more than they like their relatives. So you can set up trusts for your pets, for care of your pets in your will. And preventing elder financial abuse. Elder financial abuse is rampant. It's very often by family members. One family member is taking control over and estranged that parent from the rest of the family. There's been there's a lot of romance scams, online romance scams, and also caretakers. I'm not a big fan of the agencies that provide caregivers for people in the home. They are actually hiring convicted felons. They are so desperate for workers that they will hire convicted felons, and there have been numerous cases of paid caregivers stealing from cash, identity theft, and so forth. So it's a big problem. You need to plan have a responsible person be able to take control of your financial well-being if you become incapacitated, so you don't become victimized. We have a case out in Rochester where a caretaker submitted a mortgage application for her 90-year-old woman she was taking care of. It was all online, so no one double-checked their identity. She set up a $300,000 mortgage in her house and got her name on the deed along with this 90-year-old woman, and she's living in that woman's home right now. She's being prosecuted by the U.S. Attorney and the Monroe County District Attorney's Office too. But she was able to take full advantage. It's easy in this age for identity theft. They didn't verify anything. She took this woman to the real estate closing and had her sign all the mortgage papers and got her name on the deed, and she's living in this house right now. She will go to jail, but it's costing this woman a lot of money. These things happen quite often, and I can say that we've come across a few cases where the agencies have hired convicted felons, even those involved with theft. So wills. So the usual questions we get about wills are, I have a will, so why does it have to go through probate? So probate is this whole process that takes place down in Erie County Surrogates Court at 92 Franklin Street to authorize the executor to act for your estate. Okay, so basically, so if your mother passes away and you're the executor of her will, you can't just take the will down to Bank of America and say, turn her accounts over to me. The will itself does not give anyone any authority. The will has to go through a certain procedure in surrogates court, and the court needs to be satisfied that is a true will. All necessary people have been notified and signed off, and everyone is protected. So until that process goes through, the executor does not really have any authority to act on behalf of the estate. The executor is the representative for the estate. If there is a will, the executor takes control of the assets, pays the bills, and distributes the assets according to what your will says. You want certain dollar amounts to people. If you leave your estate equally to all your children, it'd be percentages. You can leave specific items to them if you want to leave your firearms to them or a specific car and so forth. You can also set up trust. Usually people that have grandchildren or children that are younger, maybe under 25, you can have their inheritance controlled by a trustee of your choice until they reach a certain age so they don't blow the inheritance on expensive cars or whatever else. So this is the whole process. So people often ask me, why do we have to go through probate? So probate means proving that the will is accurate. Erie County Surrogates Court is the busiest surrogates court outside of New York City. They've been operating at about 45% of their usual staff. They are highly efficient. However, complications can arise where the estate proceedings can be delayed. So the entire process from start to finish until you can actually close the estate out at best will take about a year. So this is something to take in consideration when you're planning your estate. So there's the will, and so basically when sometimes people contact me and they don't need to probate the estate. They don't need my services. So we'll talk about more in detail, but as a general rule, only assets that are just in your name alone, that doesn't have any beneficiaries or co-owners for the most part, these assets go through this probate process. So all other assets, and many people have a difficult time understanding this, do not go through the probate process. They go directly to the beneficiaries. So it's something to keep in mind. There's like I said, there's pros and cons. You don't need, like I said, you have to be careful about what you wish for about avoiding this probate process. It can be avoided. It is more expensive than the non-probate process, but we'll talk about that more like I said, if you don't have an estate plan, New York State has an estate plan for you, and that's called intestacy. So if you don't have a will, your assets do not go to New York State. It goes to your closest relatives according to the New York State law. Some of these relatives you may not like. You may end up with your estate. So we had an estate. It was about $1.5 million. This guy didn't have children or a spouse or whatever, and everything would have gone to his cousin. When he was in a hospital, his cousin looted his house. His cousin tried to become his guardian to steal all his property. I got him to sign a will 2 weeks before he passed away. Otherwise, everything would have gone to his cousin. That was the closest relative. So he left money to his church and to the Salvation Army otherwise it would have gone automatically to his cousin. So basically this intestacy about this plan that New York State has for you, if you don't have a will, then if you have a wife and no children, everything goes to your wife. If you have a wife and children, your wife gets the first $50,000 and half of your estate, and your children get the other half of your estate. Now this is what goes through probate. If you have no wife or children, your estate goes to your parents. If you have no parents, wife, children, so forth, it goes to your brothers and sisters. If you have predeceased brothers and sisters, it may go to your nieces and nephews. So that's the big picture there. So if there is no will, the representative is called the administrator, not the executor. And one of the disadvantages of not having a will is that who is going to be that administrator of your estate? Who's going to be the representative? If you don't have a will and you have 5 children, all 5 children have to agree on who the administrator is going to be. And if they don't, then the court's going to appoint the public administrator. And they're just going to, in many places, the public administrator is not going to be doling out family mementos or photographs or whatever else. They're just going to sell everything. It's not going to be like you have a friendly family member as executive. They just want to sell everything. And the public administrator for Erie County is Jen Flannery. She's appointed by the surrogate. So something to keep in mind. If you can't all agree on who's going to be that state representative, it will be the public administrator. In other counties, it's the county treasurer is the public administrator. So there is a simplified small estate proceeding if your estate is $50,000 or less and there's no real estate. You can do a small estate proceeding, and that's what I usually send people. There's a do-it-yourself, and I have links to that on my website. There's a do-it-yourself program. If your estate is $50,000 or less and there's no real estate, you can do all the paperwork yourself, or you can do it in hard copy also with forms from the surrogate's court. They have administrator or executive. It's a simplified procedure. There's only about 5 pages of documents rather than about 20 pages of documents. So be careful about who you appoint as your executor. Sometimes appointing all your kids, you don't have to appoint your kids. You can appoint other relatives to be your executor. Carry out. It's a very important job. We deal daily with, as I say, with siblings fighting where one child is the executor and he's in no hurry to sell the house because he's living there. And so he's going to drag his feet, and we have to bring proceedings in surrogate's court to compel them to do that and so forth. I will also note a new term that I just heard about recently is ghost homes. People die without wills, and then their children just continue living in the house and pay the taxes. No one's going to bother them as long as they pay the taxes and the mortgage. But the longer you wait to open an estate to transfer that house, the more complicated it gets because people pass away, relatives pass away, and then you have to possibly have estates appointed for them. So it's still, if there's no will and there's just a house, it's still a good idea to proceed with the administration of the estate with probating a will or otherwise. So when should you update your will? Certainly if you get divorced, you may not want your ex-in-laws as executors especially, or guardians for your children. You can appoint guardians for your children until they're 18 years of age to be their legally guardian in case both parents are deceased. You can also, in addition, beyond age 18, if you want management of the assets beyond 18, you can appoint them as trustees in your will. This is in addition to a living will. If your children are beneficiaries, if they go on SSI, or if they have judgments against them, you may want to adjust your will not to leave them anything because they could either lose their SSI benefits or Medicaid, or if they have judgments against them, then the creditors will seize those through the court proceedings. Something to keep in mind, change in circumstances. If you make someone a beneficiary in your life insurance, one child beneficiary in your life insurance and not another one, you may want to adjust your will for that purpose. If you have real estate in other states, like in Florida, not only do you have to be appointed executor here, but you'd have to be appointed an executor down there. That's called ancillary probate. So down in Florida, there is manufactured homes or even RV parks are sometimes considered to be real estate. So it's something to keep in mind, another reason to avoid probate and set up that ownership in a non-probate form. So, again, not all of your assets pass through what you state in your will. Regardless of what your will says, if your will is referring to non-probate assets, it's not going to have any control over that. Again, so your will is only going to have control over assets that are in your name alone. Life insurance, the first example of a non-probate asset. If you have beneficiaries, if all of your beneficiaries are deceased, then it becomes a probate asset because it'll be payable to your estate. So someone may have appointed their mother as a beneficiary back in 1955, and she's passed away and they never updated the beneficiaries. Otherwise, if you're a beneficiary in a life insurance policy, you present the death certificate and the claim form from the insurance company. It doesn't pass through your will. Uniform transfers to Minors Act accounts. You can set up accounts for custodial accounts for children up to the age of 21. Those don't pass through probate. You set those up with your bank. U.S. savings bonds. Excuse me. U.S. savings bonds. Sometimes they're payable on death. Look at your U.S. savings bonds, or they're jointly owned. If they're jointly owned, again, Those pass without going through the courts. Investments accounts, your mutual funds and your stock accounts, those can be transferred on death. It usually says on your statement, transfer on death to a specific person. IRAs, your IRAs and 401ks. I've seen people with having larger and larger 401ks through their employers. 401ks also avoid probate. You have your beneficiaries on there. Your beneficiaries can roll those over into their own accounts, inherited accounts, to delay paying income tax. Annuities, they have beneficiaries. Joint bank accounts. Joint bank accounts are a trouble area. So often there's a lot of lawsuits regarding joint bank accounts. If you add your son or daughter on your checking account as a convenience to pay your bills for you, and you pass away, that really belongs to the estate. If it's a convenience checking account, your son or daughter that's jointly on the account, they will have access to the account, but they really should turn it over to the estate. That's like an exception to joint ownership, avoiding probate. So it's a convenience bank account based on the way the bank was originally set up, or just from the way it's used. If it's your money that they're using to pay bills, and that's a convenience bank account. In trust for payable on death, transfer on death bank accounts, you can set those up too. Those avoid probate. If you're on there as a beneficiary in someone's bank account, you can have access to that without going through the court system. You can transfer one automobile up to $25,000 with a DMV, with a DMV Form 349. Another way to avoid probate is to give everything away. And we'll talk about that, about the importance of having a power of attorney to be able to make gifts. Susie Ormond often says everyone needs a living trust. That's not necessarily true. So what is a living trust? A living trust can be a substitute for a will. It's an agreement. You put your assets in the control of your trustees. It specifies what's to be done with your assets during your lifetime and how your assets are distributed upon your death. It's completely it's for the most part private, unlike a will. It'll just dictate how your estate is distributed. So why do people use living trusts? For two reasons: to avoid probate, and the other reason is to preserve their house if they have to go into a nursing home. If they want to use it to avoid their house being jeopardized if they go into a nursing home, it has to be an irrevocable trust. And you have to give a control, and you have to have someone else in control of it. So that's the primary reason most of our clients use an irrevocable trust, is to preserve their house in case they have to go into a nursing home. That goes back to what I said earlier about control, about giving up control. If you want to preserve your assets, if you're going into a nursing home, then you have to give up control. You can either give your house away a number of ways, or you can put it into an irrevocable trust in the control of your trustees. This irrevocable trust will avoid some of the disadvantages of a life estate deed. So to put your house into a trust, this trust agreement is prepared. You and your trustees sign it, and then you sign a new deed from you into the names of your trustees, so they have control of your house. You will still get your property tax exemptions as long as it states in there that you can reside there. So we could spend a couple hours talking about living trusts, but that's what living trusts are for the most part. I also talked about trusts that are created in your will. Those are testamentary trusts. Living trusts are created inter vivos, or living trusts are created during your lifetime. And testamentary trusts are created by way of your will. So you don't set up a trust during your lifetime, but it would provide in your will that if you have children under the age of 25, for example, that their money would not go directly to them, but it would go to your trustees that you've named, your brothers or your sisters, to manage that asset for that person until whatever age you think they need management till. Usually you give the trustees discretion as to using the assets, the inheritance for education, medical expenses, and so forth. They said it can be either irrevocable or revocable. With irrevocable, you pretty much are giving up control, but it has to be irrevocable in order to preserve your house if you go into a nursing home. Also, corporate stock, if you own stock jointly, that avoids probate. Limited liability companies, those can avoid probate. Ownership of membership interest in a limited liability company is often used for vacation real estate. So there's different forms of real estate ownership. Some avoids probate and others does not. So I generally have to see, in order to advise you on that, I need to see how your deed reads. If you can't find your deed, don't panic. You don't need to have the original like a car title. We can get copies of your deed from the county clerk's office. But basically, the only real estate that passes through probate is real estate that you own yourself. And sometimes husband and wife, the husband never added the wife to the deed, or vice versa, and therefore the house is going to have to go through this probate process if both the husband and the wife are not on the deed. So either if it's in your name or if it's what's called tenants in common. So basically, I have to see your deed. It would say Mary and John. It may not say anything are the owners, in which case it would be tenants in common. Or it could say Mary and John are tenants with a right of survivorship. So most likely, in cases where like Mary and John inherited the property from their parents, if it's rights of survivorship, if Mary dies, it automatically goes to John. We don't have to go through courts or anything. It automatically passes. It's a non-probate asset. Tenants by the entirety is husband and wife. So if a husband and wife purchased the house when they were married and they're still married when the husband dies, it automatically goes to the wife when the husband dies. You don't have to go through any court proceedings. You don't have to file new deeds. So we often get that question. A widow calls up and says, do I need to get a new deed because my husband died? No. She's free to do whatever she wants with the house. She can sell it, get a mortgage on it. She will just have to file the death certificate with the county clerk. So that's automatic upon someone's death. There's life estate deeds. Has anyone used a life estate deed? A life estate deed is essentially you transfer by deed your house to your son or your daughter directly, not through a trust. You transfer it to them and you keep life use. So you still are responsible for the taxes and the maintenance. You still get the property tax exemptions, and when you pass away, it automatically goes to your children without any probate proceedings. So that's an alternative to putting it in the names of your kids as trustees. The disadvantage of a living trust is that, the disadvantage of a life estate deed is that if your children go bankrupt, could be a substantial amount of money has to be paid to a bankruptcy trustee because it's in their individual name. So life estates are two levels of ownership. You keep life use, which means you have a right to, they can't kick you out. You have a right to do whatever you want with the house, but you have to maintain it. You can rent it out. You don't have to live there. And upon your death, it automatically passes to your children that way. But your children have what's called a remainder interest. They're also in the deed. So that property is exposed. If they go bankrupt, substantial amount, if you're 90 years old and you have a $100,000 house, your life estate interest, they calculate, would probably only be like 5 or 10%. So if you have a $100,000 house, $90,000 to $95,000 of that value of the house could be exposed to the bankruptcy trustee, and the house would have to be sold. Or if your children get sued, then there's judgment liens against the house too. You don't have any of that problems with a living trust because the house would be in the names of your children as the trustees. And also, if your children pass away before you do, I've seen that happen. I've seen all these cases happen, children going bankrupt, children dying before their parents do. Then it would have to pass, their interest would probably have to pass through their estate. So these are all eliminated with having a living trust as opposed to a life estate deed. We also did too was that if someone had numerous children, they would only deed the house to the child least likely to go bankrupt or get sued. And then that child signed an agreement to share the proceeds when the property is sold. So if you only paid $50,000 for your house back in 1975 and it's worth $250,000 today, if you leave it through a life estate deed or in your will or in a living trust, your children get that stepped up cost basis, so they don't have to pay capital gains on the $200,000 increase in that. So that you get that with a life estate deed. You also get your property tax exemptions. You're still entitled to that as long as you're living there. You have to be living there though. So these are the various forms of real estate that we encounter. Again, transferring your house, you can transfer it to protect it either to your children and reserve life use, or you could set up a living trust and transfer it to your children as trustees, and therefore if they go bankrupt, if they're down on a living trust, if they go bankrupt or sued or pass away, it does not affect the trust at all. And the trust will provide how your assets distributed like a will would upon your death. So also we come across a situation where the only asset in someone's name, they have all these non-probate assets, is a bank account. Or it could be unclaimed funds. Check the New York State Comptroller's website. It's free. You can check to see about unclaimed funds. If you abandon a bank account or if some check was sent to you and you never cashed it, that money goes to the New York State Comptroller unclaimed funds, so you can check that. But if you have funds there, or if your husband or wife passed away, you can withdraw up to $30,000 upon their death if there are no other assets with this affidavit here. It's a Surrogates Court Procedure Act 1310 affidavit. You don't have to go to court to have yourself appointed to get access to that insurance, certain insurance proceeds and so forth. So I have samples of that on my website, but many of the banks, like M&T Bank, they're familiar with that. Some banks may not be familiar about it, but you don't have to go through all this paperwork about getting appointed as an executor or administrator if it's only $30,000 in a bank account. If your surviving spouse or other relatives can access up to $15,000 without having to go through all these procedures here of getting appointed, because otherwise, if it's more than that, you'll have to get appointed as an administrator or an executor. So, like I said, you need to talk about the pros and cons with your advisors about avoiding this probate process. As we said, it's a lot quicker. These items 15 items that I just covered, it's a lot quicker when someone passes away to get access to these assets. Definitely save time and cost by not having to go through the court process. And so it can take a few months for an executor or administrator to get access to your assets, and they may not have the funds to pay your bills. That's one of the disadvantages of having all your assets go by way of your will through probate. You can avoid, sometimes you can still maintain control of your assets. Like I said, the big thing was privacy. All these assets that we talked about, as I said, if your will goes through probate, that's all public information. It's all available on the internet, through the web surrogate, most of your information, but not the death certificates. Death certificates are not public information. Avoiding will contests, that can be extremely expensive and can cause a delay in your estate being open. So basically, when an executor is actually finally appointed, they have to keep the estate open for 7 months. Creditors have 7 months to file claims. So if there was a person owed for credit cards, or they were in a nursing home and Medicaid's filing a lien, they have 7 months to file claims. So you have to leave the estate open for 7 months. You can still sell the property. The executor can still sell the property and manage the property, but usually the estates are open most likely for probably about a year. Just a few things about will contests. We have to go through this whole procedure here. Like I said, you can disinherit your children, and they may not be happy. They may think they have grounds to contest your will. And for instance, we talked about what happens if you do not have a will. Like I said, if you have a spouse and children, your spouse receives $50,000, your spouse receives $50,000 of the probate assets, and your children receive the other $50,000. So if you disinherit one of your children, they have a right to contest your will, because if your will gets thrown out, if the will is contested and gets thrown out, then we go back to the intestacy laws about what happens with your estate if you had, it would be like you never had a will. So that's why it's important to have your will properly done. It'd be like you never had a will, and it can be very expensive proceedings. So for instance, you leave your estate to just 3 of your kids, and you leave the 4th one out. To proceed with probate, that child that you left out has to sign a waiver that they have no objection to the will. Regardless of what your will says, we have to go through this procedure where anyone that would inherit, which I talked about at the very beginning, anyone that would inherit under the intestacy laws, they have a right to contest your will. That's no matter what your will says, no matter what you put in your will, no contest clause and so forth, they have a right to challenge the will. So, and it's very difficult to challenge a will. It could be from it could be from lack of due execution. Now, signing a will, you have to go through a certain procedure. It's not like signing a contract. If you don't go through this procedure with a will, that's why you need to have an attorney involved, the will can get thrown out. There's a certain procedure you have to go through. And if you don't go through that procedure, the will is invalid. So the procedure is that the person has to sign in front of 2 witnesses, and we ask them, is this your will that you just signed? I mean, these are simple questions. And they have to say yes, and they want at least 2 of us to be their witnesses. They have to ask, and they have to be signing in front of us. And we've had situations where wills have been done on napkins and in hospital rooms with nurses and so forth, and many times those are invalid. So due execution, there's numerous grounds but that's an important one, and I've witnessed thousands of wills in the past 44 years. So basically, the reason why it's good to have an attorney involved is because there's a presumption that if an attorney is one of the witnesses or at the ceremony, that it was duly executed. So I don't remember a will that I witnessed in 1980. But if there's a will contest, the witnesses have to come in surrogate's court, and they can be questioned by the person that's challenging the will. I don't have to remember what I did in 1980. I just have to say, my usual procedure is this. I ask the person if they read their will, if this is their will, and then they want 2 of us to be their witnesses. Wills are not notarized. They have to have 2 witnesses. So it's presumed that it was duly executed. And that could be fatal if it's not properly executed. We have some will contests where someone asked a friend, had a relative make up a will, and then they had asked a friend to witness it after they already signed it. And we have to go through this whole procedure. It's simple, but when it comes quite often is lack of testamentary capacity. Even someone with Alzheimer's disease can have testamentary capacity. So testamentary capacity is that you understand what a will is, what a will can do, you understand what your assets are, and you understand who your relatives are. So and that's very difficult to prove. A lot of times people say, well, if someone had dementia, just because you have dementia or Alzheimer's does not mean that you don't have testamentary capacity. Another common one is undue influence, someone that you trust, your caretaker, your friend, your doctor, your priest, overcomes what you normally would put in a will and gets you to leave them as a beneficiary. That's undue influence. That can be difficult to prove also, because sometimes people are estranged from their family members, and they get befriended either online or in person by people that overcome their will. So these are all difficult burdens, and that's if you're challenging a will, you have that burden. There can also be fraud. Someone forged your name on a will, signing a will. That's not too common. Or duress. Someone threatened to kill you if you didn't sign a will, threaten you with harm or violence. So avoiding will contests is a big thing. There's no advantage of avoiding probate is there's no Medicaid recovery. Medicaid can't recover against assets that don't avoid probate. And I spoke about second marriages also. Just a few risks of avoiding probate. Some people don't, just going back to living trust, people don't fund the living trust. So it doesn't do any good to have this living trust unless you place your assets in the name of the living trust. So you need an attorney to transfer the house into the name of the living trust. As far as your bank accounts and investment accounts, you don't need an attorney for that. You just have the name of the trust in that. We talked about convenience bank accounts being a problem. If you have non-probate and probate assets, you need to coordinate that with your will if you want to leave everything equally to your children, and you have only one child on your life insurance policy, you want to coordinate that. And we talked about joint ownership. So advanced directives, how many people here have a healthcare proxy? So you have a constitutional right to refuse medical treatment. I'm not talking about assisted dying. I'm talking about refusing medical treatment. You can say, I don't want medical treatment. But how do you let anyone know that in advance if you become unable to express yourself either physically or mentally about what your wishes are? So those are advanced directives. There is, back in 2010, they did pass the Family Decisions Medical Decisions Act, which is all the more reason to have a health care proxy, because the Family Medical Decisions Act, if you don't have a health care proxy, permits people that may have no idea what your wishes are to make health care decisions for you. So if you have children, any one of your children may have a right to make decisions for you. So you really do need to have it in writing as far as what your medical decisions are. So we do a combined healthcare proxy living will. Healthcare proxies came about through New York legislation. You can appoint an agent and a alternate agent to make healthcare decisions for you. Living wills came about as a result of a New York Court of Appeals case. And so in addition to a healthcare proxy, we do a combined healthcare proxy living will, but a living will gives you specific directions about what you do or do not want for life support. So if you don't want tube feeding or artificial hydration, you have to put that in writing. Your healthcare agent does not have the authority to do that for you. So in our living wills, we provide whether or not someone wants to be kept alive if they're in a coma, a terminal illness, a non-terminal illness like the later stages of Alzheimer's, and then specify whether or not you want tube feeding or artificial hydration. Everything else is disconnected. You can also donate organs in the living will. So living wills and healthcare proxies are only, they have to be witnessed by two people, your healthcare proxies and your powers of attorney, living wills are. So your healthcare proxies and living wills are only enforceable in nursing homes and hospitals. If someone's going home for hospice care and they do not want to be kept, if they don't want to be revived, then you should get a MOLST, a medical order for life-sustaining treatment. That's signed by your doctor, and that has more specifics. And so if the EMTs come to your home, if you don't have the MOLST, they're going to have to revive you. But if you have a MOLST with your directions there, or have the MOLST on your refrigerator, you can have directions not to be revived if someone is under hospice care, for instance. But anyone can get a MOLST, or also known as POLST, physician's orders for life-sustaining treatment, similar to a DNR, do not resuscitate, for specific surgical procedure if you don't want your heart or your breathing revived. If you can't request your doctor to sign a DNR, you can, your healthcare proxy can request that for you. And what age should you have a healthcare proxy in living will? Anyone 18 or over. The two most famous cases about healthcare proxies and living wills were women in their 20s. There was Terry Schiavo, who lingered for 11 years. They're fighting over whether or not to disconnect a tube feeding for her. I'm sure she didn't want to be remembered the way she was on TV. She was shown on TV with all sorts of tubes coming out of her. They were fighting over whether or not to disconnect tube feeding. Even Governor Bush of Florida got involved. They said she was going to be starved to death, which is not true. It's not, neurologically, it's not true. She wasn't going to be starved to death. And this Quinlan case, a woman that was in a coma, a woman in her 20s that was in a coma from drugs and alcohol. So everyone should have a healthcare proxy in living will. There's also HIPAA authorization, so that it should be on your healthcare proxy, so that your healthcare proxy can discuss your medical records and medical billing with your healthcare providers. So I say that in my Medicaid seminar that I present, I say the most important thing I say from that seminar people should take away from is that they need a power of attorney, and a power of attorney with gifting powers. So what is a power of attorney? Power of attorney is only valid during your lifetime. Sometimes people try to use a power of attorney to get it into a bank account after someone's deceased. Power of attorney, you can appoint someone to take care of some or all of your financial matters during your lifetime. And it's revoked upon your death, or you can revoke it with a revocation, or you can revoke it with new power of attorney. Powers of attorney, they go into effect immediately upon when you and your agent sign those. They become valid. Some people, very small percentage of our clients, are paranoid, and they don't want the agent to have authority right away. They only want the agent to have authority if they become incapacitated. So they want it in a springing power of attorney, which is a power of attorney that goes into effect when a doctor, your regular doctor, certifies that you're incapacitated. So that certification with your power of attorney validates it. So that's what a springing power of attorney is. All powers of attorney are durable, which means they are still valid even if you later become incapacitated. So when I started practicing, powers of attorney were 1 page. Now powers of attorney are about 9 pages long, and there's a good reason for that. There's a number of protections built into there because agents have taken advantage sometimes of the people who have signed the powers of attorney. There was a new law effective in June 13th of 21, a new form. If you have forms prior to that time, they're still valid, but it's best for us to see those to see if they contain all the necessary language. So not only should you have a power of attorney, but you should have a power of attorney with gifting powers, okay? So the most recent version of the power of attorney, they were changed. There was no changes for many years up until 2009. There was changes in 2010 and 2021. So the powers of attorney put limits on how much gifting your agents can do of your assets. Gifting for charity, gifting for estate planning and Medicaid planning. So there is a technique, and I'll just try to put it in the simplest terms and the amount of time that we have involved here. But that's why I say it's the most important thing. And when I talk about in my Medicaid seminar, there's information on that in my newsletter about preserving your assets. The most important thing you can probably have is a power of attorney with gifting powers. So the current power of attorney form limits gifting per year to $5,000 unless you modify it. So with this power of attorney with gifting powers, someone that's never done any Medicaid planning, never set any plans up, if they end up in a nursing home, just to put it in the simplest terms without getting involved in all the mechanics, you can legally gift half their assets. It has nothing to do with your 5-year look-back period, but it's called emergency Medicaid planning with promissory notes. So that's why I could probably spend about a half hour explaining that, but basically you need to have a power of attorney authorizing your agents to make gifts for Medicaid planning and estate planning. If you do have that, then if you end up in a nursing home, whether you have, if it's only your house that you have or $100,000, with this, if they have that proper power of attorney, the wording in that, and a power of attorney is only going to, proper power of attorney is only going to cost about $200, you can save your family tens of thousands of dollars. It's legally recognized by the courts. It's legally recognized by social services. It's something that was result of the major changes in Medicaid in 2006. I'm talking about Medicaid for assisted living. I'm talking about Medicaid to pay, not Medicare, I'm talking about Medicaid to pay for long-term care or for assisted living. If you have to be impoverished to qualify for Medicaid. And I go through all the qualifications for that in my Medicaid seminar, which is also on a videotape on our website. Another thing we often encounter is, used to be called conservatorship. If someone's incapacitated, mentally incapacitated, and they're being taken advantage of someone, it could be, like I said at the very beginning, there's all sorts of scammers out there, caregivers, family members, and so forth. A guardian can be appointed for them. It's under the mental hygiene law here in Supreme Court, in the Supreme Court in the county where you reside. It's called guardianship. So why do we sometimes need guardianships? Well, we often see powers of attorney do not have these gifting powers. So if someone's in a nursing home and they have substantial assets, even their house, the house has to be sold. And like I said, there is a procedure to gift half the value of the house. So we can have guardians appointed through this Supreme Court proceeding. You could have a guardian appointed for your mother or your father. The proceedings can take probably at least 2 or 3 months. So that's why it's better to have a power of attorney with gifting powers so you're not running up the bill at the nursing home. But anyway, sometimes people do have powers of attorney, but they don't have gifting powers. So sometimes we have guardianship set up just so they can gift their assets. And like I said, the judge will order authorizing these gifts to family members in accordance with what the person's wishes would have been, sometimes evidenced by what their will says. So that's why, so guardianships are set up for those reasons. Sometimes a power of attorney is taking advantage of a person, stealing from them or using their credit cards. Then we have guardianship set up for that reason. For incapacitated people, incapacitated adults, it's a very flexible system. It used to be called conservators, and they will only give the guardian so much powers as is necessary to protect that person. For the guardians of their person to decide where someone may have to, what nursing home they're going to go to. You can't force someone to go to a nursing home. A guardian could be authorized to place someone in a nursing home or provide or make medical decisions for someone. And a guardian of the person's property would have control over their assets to make sure they're protected. So I've seen some LegalZoom wills, people getting wills online. As I said before, you can prevent or minimize will contests if you have an attorney prepare that. So LegalZoom, they don't provide legal advice. They're probably not that much cheaper than an attorney to prepare your will. So, or even getting forms from somewhere online or whatever. So, burial designation forms. Some people, and this happens, sometimes relatives will fight over where someone's going to be buried or whether they're going to be cremated or not. That seems to be a common, or what's going to be done with their ashes. So if you anticipate there might be some issues with your relatives and you're not married or have close children, then you can sign a burial designation form to specify your burial arrangements, and also pre-planning your funeral. If you set aside money with a pre-planned funeral, that money is exempt from qualifying for Medicaid. You can set up your money in trust with a funeral director and have all your plans and have everything prepaid for your funeral and protect that money so that your relatives don't have to pay for your funeral. So we covered a tremendous amount of material today. Like I said, well, first of all, I appreciate if you complete the comment forms. I'll take questions now. I can stay after the question session. If you want a free estate planning or Medicaid consultation, I can give you the intake forms for that. And this presentation video will be on my website. And also I have my other 15 ways to avoid probate and 14 ways to preserve your assets within Medicaid laws, videos, and free guides on our website, wny-lawyers.com.